afternoon and welcome to CUHK Law. My name's Stephen Gallagher and I'm the Associate Dean for Academic and Student Affairs. And it's my pleasure to welcome to you to this seminar today, which is being presented by the Centre for Comparative and Transnational Law, and that's the cluster for corporate law and corporate governance. We have two great speakers for you today. Our main speaker is Ms. Tracy Cheung, and then we have as discussant Professor Chao. Before I introduce Tracy, let me just say to you that I'm sure at the end of this presentation you will have some questions. So please feel free to use the chat function to send in questions, and we will try and reserve some time at the end for a Q&A session. But now let me introduce Tracy to you. Tracy Cheung is a qualified solicitor in Hong Kong and England and Wales with over 15 years experience in healthcare and commercial litigation and advisory work. She was a partner at Kennedy's before starting her independent healthcare focused advisory and alternative dispute resolution consulting practice. She's an advocate of lifelong learning and provides professional training consultancy services through the TMed company, working with universities, medical and legal academies, associations and global indemnity providers. Tracy is also an accredited general mediator, a member of the Hong Kong International Arbitration Centre, and a member of a number of mediation centres. I won't go through all of the different qualifications, Tracy, if you don't mind, because I think they're accessible on the website. As the honorary legal advisor to the Hong Kong Health Education and Health Promotion Foundation, she works closely with the School of Public Health at the Chinese University on public health education initiatives. She's passionate about public health education and she continues her postgraduate studies in public health with Imperial College London. She's also actively involved in local NGOs, SMEs, and conservation projects, adopting and empowering an educational approach. So public health has never been more important, I think, to all of us. And this is a particularly interesting aspect of that. So without further ado, I'll hand you over to Tracy to talk about gross negligence manslaughter and lessons learned from a particular case in Hong Kong. Tracy, over to you.
Thank you, Steve, for that kind introduction. Good afternoon, everyone. Welcome to this seminar. I'd just like to share my slides. Just bear with me at this moment. There we go. We're all set. Yeah. Right. As I said, the title, Gross Negligence Manslaughter, Lessons Learned from the HK SAR series of cases featuring Dr. Chao Wing, Cheung and Mak Kwan Ling. I think many in Hong Kong would know this case as the DR case, involving the DR beauty clinics and unfortunately resulting in the unfortunate death of a lady, Madame Chan Yun Lam, following severe septicemia resulting from contaminated CIK therapy treatment. Now, an overview of my webinar today will last for about 45 minutes, and please feel free to put your questions in the chat function later. First of all, I'll look and remind you of the elements of the offence of the criminal offence of gross negligence manslaughter in Hong Kong. Got very interesting case law on this, leading to the Court of Final Appeal ruling in the case of Dr. Mak, who appealed in relation to the test of gross negligence manslaughter in this case. That was decided back in 2019. And following on from that, I'll briefly go through the case of the DR cases, picking, my brains and discussing with you some of the valuable lessons that we can actually learn from this topic, not just from a healthcare and medical profession perspective, but in keeping with the theme of this seminar cluster on corporate law and governance, what it means from the perspective of the owners and employees actually who participate or involved in these treatments, which pose a health and a safety hazard to patients that extends from there. And we actually have a very recent case involving the death of a patient after the liposuction procedure went terribly wrong in the case of Dr. Kwan Hao Chi. That was just, Dr. Kwan was just sentenced earlier this month to 6 years imprisonment. She was convicted of 1 count of gross negligence manslaughter. Thirdly, I'll turn on to look at the impact of these cases on private corporate healthcare providers. What I mean by that is the growing number of chains, both private and listed corporations, which provide healthcare services, a growing trend in medical aesthetic practices, which include Botox treatment, liposuction, and other beauty and therapy treatments. And the impact of these cases on the regulations and regulatory landscape has there have been a lot of calls for tighter regulation in this area. So looking at the elements of the offence of gross negligence manslaughter, I'll go back to just provide an overview of the basics in this area. Gross negligence manslaughter is a criminal offence under the common law and punishable under Section 7 of the Offences Against the Person Ordinance. Maximum penalty which it attracts for people convicted is up to life imprisonment. It's a very severe offence, and the Hong Kong courts have, following recent years, in particular the series of DR cases, follow the English House of Lords case principles in relation to elements of defence which the prosecution must prove and the jury must find in R and Adamaco. Now, in a case in R and Adamaco back in 1995, this involved an anaesthetist, Dr. Adamaco. He was responsible for not just administering the anaesthetic for the patient undergoing eye surgery, but the additional and very important responsibility for the anaesthetist is to monitor the patient's vital signs. In particular, in this case, when the patient was actually intubated, so that means that he actually received oxygen. He was breathing through a machine with a tube connected to his mouth and connected to the ventilator. Unfortunately, Dr. Adamaco failed to notice that the tube connecting the oxygen to the patient had become dislocated during the course of the surgery. This resulted in the patient suffering deprivation of oxygen. Basically, he couldn't breathe. And because of failure to notice this, the patient actually went into cardiac arrest, suffered a heart attack, and actually died. In this case, Dr. Adamaco was convicted by the jury of 1 count of gross negligence manslaughter and was sentenced to 6 months imprisonment, suspended for 2 years. Now, a summary of what the elements of the offence of gross negligence manslaughter must be proven, and it essentially is for the jury during the trial to find, is that firstly, the defendant owed the deceased a duty of care. So there must be a duty of care between the defendant or accused and the deceased. The defendant actually breached that particular duty of care. Thirdly, it is reasonably foreseeable that the breach of that duty gave rise to a serious and obvious risk of death. The defendant's breach actually caused the death, so the causation element, importance there. And fifthly, and most interestingly, in causing the most debate and common law discussion and appeals, etc., is the fifth element where the defendant's breach amounts to gross negligence and is therefore criminal. Now, back to the basics, it's not merely negligence, as in many cases when involved, doctors may be negligence for causing personal injuries to a patient. In this fact, that because it's criminal, warranting punishment, very serious offence, it's what amounts to gross negligence. Important thing is with this, it's for the jury. It's a question for the jury, not a matter of law for the judge to direct or decide. The jury has to determine this based on the evidence and the proof and the evidence provided by the prosecution. Now, fortunately, in this series of cases, the DR cases, we have clarity on this area. It's very important that the landmark case of the Court of Final Appeal, I've set out the citation here, which states that the test for gross negligence is actually the objective reasonable person test. So the person accused or defendant is judged by what is reasonably expected, the standard care expected of that, and which gave rise to serious and obvious risk of death. What happened briefly in this case is that Dr. Mack actually appealed following the Court of First Instance ruling by Madam Justice Barnes, who actually ruled that the test for gross negligence manslaughter in Hong Kong actually departs from Oren Adamako. It's not simply just the objective reasonable standard tests. There should be an additional limb for the prosecution to need to prove to the jury that the defendant in question was actually subjectively aware of the serious and obvious risk of death in this particular case. So in other words, in order for the prosecution to prove that Dr. Mack, say in this case, was guilty of gross negligence manslaughter, she had to be herself, has to be proven she was aware that there was serious obvious risk of death in that case, in this case. So obviously that's a higher standard, an additional limb to be proven. What the Court of Final Appeal determined was, no, this is not the case. They overruled the directional ruling of Madam Justice Barnes in the Court of First Instance and said, no, it's not necessary to prove this limb. And obviously, Dr. Mack wanted this test to be proven so it'll be more difficult for the jury to convict her, because following the first trial in 2017, the jury were unable to reach a verdict. And she could not be convicted in that case, so a retrial was ordered. Now, in order to determine whether the breach amounts to gross negligence and is criminal, it's necessary to look at the conduct of the individual defendants. And it has to be said that the standard is high and the conduct has to be so bad, considering all the circumstances, as to amount to a criminal act or omission. Now, criminal act or omission punishable by imprisonment is obviously higher than your usual civil standards, where there's just negligence, where alternatives say to Dr. Mack, if she's not convicted, gross negligence manslaughter is additional claim in negligence in the civil standards required as low in balance of probabilities, and that she caused the death of the deceased in this case. Now, looking onto the DR cases in more detail, in tie with the theme of this webinar, looking at corporate governance and governance in this respect, we'll look at more detail at the three defendants which were actually convicted in this case. All three defendants were convicted in the end. Who received the heavier sentence was actually the first defendant, Stephen Chao, who essentially was a medical doctor but ceased practice after founding the DR group back in, I think, in 1994. He was in effect the hands-on boss. That's what the trial judge called him. He was in effective control of a network of DR companies who were involved in the CIK therapy treatment, from the employment of Dr. Mack to administer the treatments to the customers and to her patients, to the actual setup of and operation of a laboratory in the Hong Kong Science Park responsible for processing the CIK blood products involved in the CIK therapy. All three were convicted. The second defendant, Mr. Chan, the technician at the laboratory who's preparing the CIK blood products. In brief, I think many people know the facts of the case, but what happened in this case, brief overview, is that the CIK therapy treatment actually is an experimental form of treatment, primarily for cancer patients, usually late-stage cancer patient treatments to prepare palliative care and relief. It's an immune-boosting therapy using the patient's own blood and using cytokine to induce the production of killer cells which are present in people's bloods to actually multiply in a great abundance, with the therapy that after extracting this blood from the patient, processing in the laboratory, infusing it back into the patient. It's meant to boost the number of immunity and killer cells in that respect. Now, as you can hear from this process, there are risks involved in the whole process. And what unfortunately happened was the blood products of the deceased, in this case, Madame Lam, as well as two other ladies also involved in the civil claims suffering severe injuries, is they suffered from blood poisoning after their contaminated blood products was infused back into their blood system. Unfortunately, in this case, it led to the death of Madame Chan from severe septicemia, blood poisoning, and multi-organ failure. In summary, there was a 100-day trial back in 2017. It was well reported in the news, and the jury were actually quick to convict by a unanimous verdict, the first and the second defendant. First defendant was sentenced to 12 years imprisonment, second defendant to 10 years. No reduction was made for any after hearing the mitigation evidence. The sentencing judge was very strict and said that heavy sentences needed to be imposed to actually show the shock and disgust express the fact that the defendants disregarded the health and safety of this lady and many others in promoting and administering this CIK therapy. The third defendant, Dr. Mack, as I said, she appealed to the Court of Appeal, Court of Final Appeal on that question of law I discussed, where we confirmed the objective test, reasonable man test for gross negligence manslaughter. Following her retrial back in 2020, she was also convicted after we sought clarity in the law and sentenced to 3.5 years imprisonment in December 2020. Now, looking first at the first defendant who founded the DR group, and there's a number of companies involved. He was basically 100% the owners of all these companies, elaborate structure. He had legal advisors, and there was waiver of disclaimer forms waiving liability resulting from any injuries from this CIK therapy, and lots of thought put behind this business, which was set to be listed on the Hong Kong Stock Exchange. He conducted the sales administration of a number of beauty and medical aesthetic services, including this therapy. This therapy just represented a small proportion of the proceeds and the profits generated. What was shocking and was discussed by the judge was the fact that he employed doctors such as the third defendant to administer these treatments to the customers of the beauty centres, where the beauty centres were actually not known that these doctors were actually employed by the company. For them, this represented an independent medical professional who they sought advice and advised them to receive these treatments, including a CIK therapy, which is a immunity boosting treatment. This was unknown to them, and this was all part of a very elaborate business there. And the jury was not hesitant to determine that the first defendant breached his duty of care to Chan Yun Nam. It might appear remote that he did not know this particular lady. He did not administer or promote this service to Madame Chan directly. However, it's very clear in this case that he was behind the introduction of this therapy and marketed this aggressively through his companies, through this employment of Dr. Mack and many other doctors. So he breaches duty to Chan Yun Nam. I've set out here the particulars of breach of duty, which the jury found was established and set out in the indictment. Primarily, it relates to the failure of Mr. Chow to ensure there's a properly qualified person responsible for preparing such blood products and this invasive therapy that is provided. He failed to ensure that there was the proper followed up protocol. There was actually no written protocol after the police seized all the evidence in this case to show the steps that were carried out, the need for tests to ensure that everything was sterile, the products were safe, and there was no sterility tests carried out for these blood products for this batch. And he failed to inform also that Madame Lam was aware of the risk involved in the administration of this therapy. He pleaded not guilty. He called lots of evidence. Part of the lengthy 100-day trial was a majority part taken up by his evidence, and he was at pains to distance himself in order to try to persuade the jury that there was no breach of duty. He didn't owe this particular duty because he was a mere investor. He wasn't really in effective control of the companies. They ran themselves. However, of course, this was not accepted by the jury and greatly criticized by the trial and sentencing judge. Aggravating factors making this case such shocking and warranting the heavy penalty of 12 years imprisonment I've set out here. There was aggressive marketing stance, lots of things driven by money without regard for the health and safety of these customers, unaware of the effectiveness or ineffectiveness really, and the ways that there was no safety checks or protocols and properly qualified persons to handle these blood products where they were actually infused back into these patients, causing severe injuries and death. There was also the disclaimers which were signed by these individuals, waiving liability against the DR company or the doctors involved. And I've quoted here how Madam Justice Barnes set out it was so disgraceful, irresponsible for the first defendant and his group of companies to shirk their responsibilities to the very gullible and trusting customers, including the deceased, to sign such disclaimers. In terms of mitigation, the sentencing judge was not sympathetic at all to all the evidence submissions provided. And in her view, the case did show that there was truly exceptionally bad and it was such a terrible crime that committed that the heavy sentences needed to be imposed to send a signal to society and potential people who could involved in similar therapies that, the discussion by society is great. Looking at from the employee's perspective, in this case, the laboratory technician who's responsible for processing the blood products, he was also found guilty and the duty of care was established. He in particular had failed to ensure he himself was a properly qualified person responsible for dealing and managing with the CIK cells therapies during the culturing process, where of course there is a risk of contamination and infection. He himself, the jury found from the evidence, he was aware of this obvious risk of infection and death of patients, and however, he simply failed to conduct a sterility tests on these blood products or document any of these in any of the documents seized. He also in particular failed to ensure there was a safe system in which a document showing the sterility test had been conducted to accompany the blood products when they were sent, processed from the laboratory at APSC, sent back to Causeway Bay in the Mesotherapy Centre, and then given to Dr. Mack, who was the doctor in particular who was responsible for infusing the blood products back into the patient. Although he also pleaded not guilty and elected not to give evidence, as I said before, he was aware that CIK therapy was experimental treatment. There was no scientific conclusive evidence to show the efficacy for not just cancer patients, but in this case, in healthy patients to actually boost their immune system, for which this effect was actually aggressively marketed, and was the reason why Madam Chan agreed to undergo this therapy in the first place. In his defense, he did try to argue through his counsel that the failure to carry out the sterility test was an error of judgment. This was rejected by the trial judge and obviously by the jury who convicted him. It is really obvious, and it would obviously go by the reasonable standard, that it was a deliberate conscious decision not to make a not to carry out a sterility test. It should have been fully aware of, of any reasonable person in Mr. Chan's shoes to actually know that. So in the end, he was convicted to 10 years. And again, the shock and disgust felt by society is reflected in his sentence. Looking at the third defendant, Dr. Mack, this was more problematic for the jury. And in this case, for the jury to determine, and following the retrial, however, with the law set out clearly that about the objective reasonable man test for the gross negligence manslaughter, Dr. Mack was found she had breached her duty to ensure that the bacterial tests had been conducted on the blood products and documented. In her defense, she claims that she had relied on the staff and for the laboratory, in particular the medical director, who used to be her lecturer, specialist in hematology, who was employed there. She thought that, she placed trust in her employer, the first defendant, that she thought, I didn't need to carry out these checks to ensure that these sterility tests, bacterial tests, she assumed that they would be carried out. She didn't need to check the paperwork. She never questioned. And unfortunately, that was not sufficient. And trusted with the doctor and patient relationship and the trust placed in her as an independent medical professional, she should have obtained proper informed consent from Madam Chan, which involved the discussion on this nature of the therapy, the fact it was still experimental, no scientific proven benefits for Madam Chan in this case, and the fact that it does carry with it a risk of infection and contamination on the patient when it was administered. The fact that she failed to advise of any of these risks, and the only risk set out in the disclaimer form, which the patient actually signed, was the risk of fever. There was no discussion on the benefits or, with scientific proof, and the risk in effect were life-threatening and were not discussed at all. And in any case, the jury held that this treatment was not suitable to be carried out in the circumstances at all, never mind just for this particular patient. The trust that she placed in the first defendant and the group and the reliance, assuming there was a safe system during the process, was severely criticized. She was sentenced to 3.5 years and received some sympathy from the judge as she showed some true regret of what had happened and her failure to carry out these necessary checks. The time was saved because she was cooperative with the prosecution. She admitted much of the prosecution evidence. This saved a lot of time during the trial. And the fact that this case was hanging over for 8 years, she went through 2 trials, appeals up to the court of final instance, and she was suffering and showed remorse that a reduction of 1 year was actually given. Now, the most recent case, which I've turned here, is very interesting. You would have read in the news. It's very, very recent, following the death of a female patient undergoing liposuction therapy at actually a hair beauty treatment called regrowth hair treatment in Chim Sa Choi back in June 2014. There was considerable delay in the prosecution in this and the DR cases. What happened in a nutshell in this case was Dr. Kwan was a GP. She was responsible for providing liposuction treatment, removal of fat from this patient. This was the second time she actually conducted similar surgery on this patient. But in this case, she actually resulted in the unfortunate death of the patient, where following a 3-hour surgery where the patient remained under sedation, she was left in the care of 4 untrained assistants, and the monitoring machines, monitoring her vital signs, etc., was disconnected, and she was just left in the care of assistants, including some beauty therapists and receptionists, to monitor. And it's only when they happened to noted that the patient was actually beginning to snore less and her face suddenly turned pale that they knew that something was wrong, and they alerted Dr. Kwan to return, and emergency services were called. Unfortunately, the patient failed to regain consciousness. No resuscitation was carried out, no oxygen was given, but once she was rushed to hospital by the emergency team, when they attempted to resuscitate her, she was certified dead. And in this case, Dr. Kwan, she pleaded not guilty to the charge of gross negligence manslaughter. However, the jury were quick to convict her, and she was found guilty of gross negligence manslaughter and sentenced to 6 years imprisonment. This is considerably a heavier sentence than Dr. Mack in this case. There was a number of issues which were very serious in the fact that it brings to the forefront the fact that in such similar beauty centers, surgeries which requires should actually require properly qualified persons present, such as anaesthetists, to actually administer sedation and also be present to monitor the vital signs and the condition of a patient who was sedated for more than 3 hours, and where Dr. Kwan herself was busy carrying out the surgery. No proper checks was made. This patient in particular was a vulnerable patient. She was obese. This would put her at risk of cardiopulmonary complications during surgery. She was placed in a prone position, face down on the operation table. There was no attempt to actually turn her after the completion of the operation. That actually put her at further risks. And no oxygen was administered, and there was no sufficient monitoring, there was no documentation. She was linked up to a machine monitoring her vital signs, which would alarm when there was abnormal vital signs readings. However, this was switched off every time it actually sounded. The evidence given through the video camera evidence and also Dr. Kwan, it arose the reasons why, it was ignored. It's because they thought the alarm was too sensitive and it didn't cause any issue. So there's great failure to actually monitor her safety. There was just no regard really for her health and safety and life in this case, leading to her unfortunate death. So what can we learn from these cases? There's lots of facts and things to process there, but I'd like to highlight that what this poses is it's a reminder of the risk of gross negligence manslaughter. In the past, there are very, very few prosecutions and convictions. This has come into the highlight in the past couple of years following the DR case, and now Dr. Kwan. And we've also got another doctor, Dr. Franklin Lee, who has been charged with gross negligence manslaughter following the death of a lady after receiving numerous Botox injections at a clinic also. In that case, we'll yet to see the results, but I'm sure with the law very clear and these convictions and precedents that there is further prosecutions and convictions following. The court's very strict approach to sentencing is adopted, and you can note it. And this hopefully will send a warning to not just the medical profession, but anyone involved in these procedures, which poses risks to the health and safety of patients and customers, who very often can be termed as gullible and place trust, in particular when medical professions are employed and who give them the actual treatment. Great trust is placed in the profession and also in these centres with the well-known names. Patients' lives and safety, the importance of this is paramount. I can't stress how important that is here. And the process of informed consent taking, not just for the medical doctor involved who are administering the treatment, but the fact that this does not offer any protection through these disclaimer forms which customers or patients are asked to sign in the process. It also highlights the low levels of regulatory control for these beauty centres or medical aesthetic centres, which pose high risk to patients. And we hope that the public will actually be educated and become more aware of these risks that they pose, to ask the necessary questions, and also to ensure that the managers and owners of these centres also have these health and safety procedures and checks in place. So about the impact, I'd just like to outline the impact of gross negligence manslaughter on healthcare practice. I've highlighted in the middle, I mean, what it means for corporate healthcare providers, you know, from the corporate perspective, the owners, the managers, senior managers involved, the people who run these chains of clinics providing these treatments, they are risks. And you would have thought that maybe receiving a Botox injections do not posed any risk, but yet in Dr. Franklin Lee case, the patient, she received many injections, but it only takes, you know, one unfortunate incident to result in, you know, a death in that case, and prosecutions in this respect. Risk of corporate manslaughter and fines, I've set here as a question. Interestingly, in these cases, even though the specific companies, private companies involved in the DR group were identified, they were not actually, prosecution did not seek to prosecute, lay any charges against the corporation itself. They actually went directly against the owners, the individuals involved, the laboratory technician, the doctors involved in there. This is another area which we can discuss later, and I'll speak with Mark on this because there's further developments in England and Wales in this respect. Concerns from the medical profession, I've had from the contacts and my clients that these cases cause a lots of worry and stress for medical professionals, because where there is risk that it goes beyond prosecutions for beauty center therapy clinics and things where there might be medical errors and there are deaths in many cases in hospital and clinic setting during procedures. There are always risks of complications of any surgery, and whether the medical profession are greatly concerned that the prosecution in Hong Kong will seek to criminalize medical errors and start laying charges and criminal investigations following these deaths. I've yet to hear from the prosecutions or any trend in this respect, but it's an area which we've, you know, get to look out for, and it does raise to the forefront this concern, and doctors themselves need to protect and also ask questions of their employers where they're involved in these high-risk procedures, or whether, even if they don't consider them high risk, whether there are additional safety processes and knowledge that they should possess and discussions that they should have with their patients. Thirdly, as a public concern raised arising from these cases, there's calls for strict and tighter regulations on this, in particular in the beauty setting, beauty clinic setting, or private clinics. We see a greater number of these private daycare procedures clinics, or on the high street, where there might not be greater regulation for persons individually to whether they have the necessary experience or qualification to administer these treatments, because say like Botox treatments and these therapies can be administered by a general practitioner in such a setting. However, as a result of the DR cases, the government and the legislature have looked into this respect and considered other jurisdictions and laws, and has come into effect in gradual phases a new licensing scheme under the Private Healthcare Facilities Ordinance, covering a range of daycare centres to clinics, setting out strict requirements for what equipment and safety procedures and personnel responsible during the operation of these facilities, and it's a condition of them to hold the license, and where they can be subject to checks by the Department of Health in this respect. So this is a positive way forward, where there's new regulation system in place. But as this the legislation is being introduced in phases, licensing scheme is gradually being introduced, we really have to watch this space to see the developments in this area. So this actually concludes my presentation on this subject, and feel free to put questions in the chat, and now I'll hand you back to Steve. Thank you, Steve.
Thank you very much, Tracy. Lots to think about there, really interesting. All of those aspects of well, those two important cases and everything to do with gross negligent manslaughter. But now it gives me pleasure to introduce our discussant, Professor Mark Chao. Mark is a former colleague from CUHK Law, but he's now over in the UK, so he's gone up very early in the morning to join us today and give us his expertise on this side from a more perhaps English perspective and the scheme of things in the UK. So Mark is an associate professor at Leicester Law School. He's taught at universities in the UK and of course here in CUHK Law as well. His research interest lies in mainly finance and banking law, in market regulation and in corporate governance as well. And of course, very importantly, in the law of equity and trusts as well. So I think at one point we were going to teach a course together, but we never got round to it, did we, Mark? So, but he's been published widely in academic journals. He's been cited in court decisions in Singapore and other jurisdictions as well. As I said, widely published books on financial law and again the intersection with commercial law as well. But Mark is here today to talk to us about this aspect really of corporate governance, gross negligence manslaughter. So Mark, can I invite you to comment on Tracy's presentation and add some of your own information as well. Thank you very much.
Thank you, Steve, and for the kind introductions. And thank you, Tracy, for such a informative information, what's happening in Hong Kong. I'd like to start by asking a bigger questions, which is on your last slide, the very first question regarding the corporate manslaughter and homicide acts in the UK. You did mention that, which is something I have a question, that why the Hong Kong did not pursue on the corporate aspects. And it seems like Hong Kong doesn't have problem at all through the traditional common law structure to go after those individuals. And that approach seems to suggest that there's an ignorance or the corporate veil, or lifting the veil, just go straight to the crime, to the actual person directly. And that kind of cuts through the hurdle which we had in the UK for many years till the corporate manslaughter and corporate homicide acts, is that the difficulty is you had to identify individual within the article association and then ping on to within the seniority of the groups who has such a knowledge, and then to attribute that knowledge to the corporation. It's because for cleaning center like this or any other corporation, we all know that the direct contractual relationship between the victim is built between corporation rather than individually. So this is something really puzzles me. So my bigger question is, will Hong Kong follow the suits of the UK Corporate Manslaughter and Corporate Homicide Act 2007?
I think according to my understanding is there has been discussion on this, whether the Hong Kong should follow suit. Unfortunately, there has been no pressure in Hong Kong to actually from the public and from individuals or parties involved in these cases for a push for this. So you're right to state that the Hong Kong follows the common law, the common law's corporate manslaughter provisions. And so they do have those hurdles to actually, if they are to prosecute the company itself. It's interesting for the DR, the cases, the fact that they didn't go after the corporation. I think this very much is limited on the scale of things, the fact that this was a limited group of companies and the individuals could be identified very readily, or the evidence, Stephen Chao in this case, he was named as the director in all these cases. He was very prominent as the owner and the face of this company, and he was actually involved in press conferences and promotions. This material, it's very easy for the prosecution to actually place kind of like the blame on him, and also the technician in the case. But it'll be interesting, as you've noted, from the UK position, where there is a need then in future, say a similar case happens, but it's part of a large listed corporation. where there's further, obviously distancing from who was responsible. You can't go after, the top man in the company, the chairman, where they say it's a whole large chain of, say, beauty clinics, and it might have been the responsibility of certain subsidiary companies to decide to employ certain treatments leading to, the death of a particular person in the case to do that. So from my understanding is really there's no push at present for Hong Kong to enact Corporate Manslaughter, Corporate Homicide Act. I think from my understanding and knowledge in terms of corporate manslaughter, only in the past there has been one conviction in the past, and this was back in, I think it was back in the 90s, involving in 95, involving Ajax Engineering and Surveying firm, following the deaths of 12 workers on a building site when the crane attaching the lift, carrying them actually snapped and resulted in the death of the workmen in the lift, actually free fall on the damaged site. And however, in that case, the company were to defend the corporate manslaughter charges, but a few weeks into their trial, the evidence showed that there was damaging evidence showing that the firm actually had in the past, and then for this case, fabricated safety check evidence, as they were responsible for ensuring the safety of the lifts and the equipment on the site. So they actually pleaded guilty during the course of the trial, and the firm was fined 3 million Hong Kong dollars in that case.
Yeah, you kind of answered my next question I was going to ask, in the sense that the comparison, it seems that all the cases you have in Hong Kong apparently is still very similar to the English common law tradition that Leonard Air and Farming, which is considered individual company, and where you have a few employee only. And when you compare to large corporation like Tesco or Litigation construction big company, where the litigation actually will be had to be held accountable to attribute the company as a whole, where remotely his employee somewhere in a site, which is depart from it. So the question, it seems like in Hong Kong currently, the individual prosecution based on gross negligence, it takes some time for the prosecution to collect evidence. Would it not be better if you have something like the UK model, then the prosecution can move quickly, although not a perfect scenario, because under the UK Corporate Manslaughter and Corporate Homicide Act, individual will not be personally liable. They won't go end up in prisons, but the corporation will have a corporate fine and spread it throughout the period. Say, for example, UK, the very first one after the Act was the Cotswold case, which was fined for £380,000. But so the question back to you here is really, do you see the needs of this to accelerate, to bring some sort of justice in a way to the victim rather than taking some time?
Yeah, I believe so. And for this, for these cases, the prosecution did have to take many years and had to see so much evidence. And I heard about the time and evidence needed to draft the indictment to establish all these individual breach of duty issues. My brief understanding of the Corporate Manslaughter, Corporate Homicide Act in UK sets this out. There's a statutory framework. There's things to look at. The activities that the corporation actually, the way that they manage their activities, organized in health and safety respects, can be taken into account. And a very clear framework I agree, would be very helpful and would shorten the criminal investigation and prosecution process. And I think increasingly for similar cases on the larger scale, having statutory provisions would make it much easier and quicken the prosecution process.
Yeah, it sounds like Hong Kong has a very flexible mechanism, and it seems like the judge still very in line with the society, social view in the way of justice, punish the wrong to the public in a sense, and without going through the amendment like the UK with the corporate manslaughter and corporate homicide acts, which essentially was quite difficult to justify, because the legal formalists believe that in order to prosecute them successfully, you need to go through the legal theory hurdle of corporate structure. And it's always been very difficult in a sense. And I think there's a lot of similarity as well. You mentioned about the subjective elements of the defendant, which is very similar here, is no longer applicable anymore. Because if you allow them to have a subjective you allow them a defense basically to have this subjective knowledge. So it's now being wiped out. It's purely objective and purely judged by the jury in that sense. And we do have quite clear a guideline specific for the corporate manslaughter and corporate homicide act, which the judge will pass on to the jury to consider on those points. But very interesting, I mean, UK has divided the prosecution on this area into two ways now. One is you prosecute corporate in one sense, which make corporate liable and shame them on the public news. And on the other hand, you can go after again individually through the Safety and Health Act 1974. And all depends on which act, then individual will go to prisons and being personally accountable. And funny way is that a lot of corporation, I follow a few cases in the past in UK, is that despite the effectiveness of corporate manslaughter and corporate homicide act, able to prosecute the company successfully, this company, once they're being convicted, they enter into insolvency procedures very quickly into its time, and to avoid the liability. And then that is really, that's why I say it wasn't really a perfect situation, but at least to some degree a fairness or justice. So what do you think whether Hong Kong will go on in sort of, whether would it be parallel way or still keep on this common law structure?
I think there is, I think there would be an interest in following the UK system. I think with in the interest of, you know, the public interest with greater corporations and the fact that many companies are, you know, seen as, you know, large and money making, but they have to be accountable, say, for any accidents, say, of their employees, or for cases such as in the Ajax engineering case that I've mentioned, where, you know, 12 workers who actually, you know, died during the course of their employment due to the defective crane which operated the lift. I think there should be, personally, such provisions and holding these corporations liable, and it also serves as a public deterrent as well for corporations, the managers, for the CEOs, that, you know, the greatest, you know, the sanctity of life and the importance of health and safety to the public and to their own workers, because very often these cases are involved, you know, the accidents and deaths of employees, and they should be held, you know, accountable, and the prosecution process should be more efficient.
Thank you so much. That's very informative. Yeah. I don't know, did I hold on too much question to you? Would it be, Steve, I don't know whether we should open to the audience, or, and then Bonnie, sorry, Tracy, and then I can try to answer both ways, either Hong Kong or UK perspective.
Okay, fine. We can open up for questions. We've already had some questions, but just to remind everyone, you can use the chat function to come in. Can I just ask a question first to this, to Tracy, on the case of the liposuction case, the Dr. Kwang case. You'd said that one of the most important elements is to establish causation. And I remember this case being reported, but I haven't read the case itself. Was there any issue with that because of the fact that, as you said, it seemed that the cause of death couldn't be ascertained?
Yes, this is actually an interesting point, because when you look at it, as you say, on a strict reading, it assumes that, you know, must be breach of duty and there must be very clear causation what actually caused the death. But I think in this case for the jury to find this, so the fact that if she hadn't received sedation. She hadn't undergone this procedure performed by Dr. Kwan. The fact that she was left, the operation theatre after the performance of the procedure, she wasn't carefully monitored, she wasn't given oxygen, and even when at different stages when her life was at risk, the alarm was sounding, that was ignored during the liposuction procedure. Afterwards, when Dr. Kwan left her, she was still unconscious, lying down in prone position. After several hours, left in the care of untrained assistants, and the fact that she might have been suffering and could have been saved, her life could have been saved at that stage, amounts to the fact that I think the jury drew the conclusion that it was the result of the breach of duty throughout the process, from the failure to conduct all the safety and checks and also monitor the her condition during and after the liposuction process, and the fact that even when her life was at risk, there was no resuscitation carried out. She wasn't there. There was an anaesthetist present for her to do that, and by the time emergency services sent the lady, to hospital, it was too late. And so, despite there was a lot of evidence called during the trial from experts who tried to consider the exact cause of death from the post-mortem, and they couldn't ascertain the exact cause of death. I think for the purposes of the making out the offence, the jury drew, the conclusion that it was but for really, or the conduct of Dr. Kwan, the patient wouldn't have died.
Thank you. Well, I suppose it's the overlaps with the sort of the common law concept of negligence anyway. It's almost that the thing.
Almost but for.
Yeah, well, and the thing speaks for itself almost.
Yeah, exactly.
We can't point to what actually happened, but something must have happened. I see that Professor Peter Rhodes is with us, so he may have a comment on that at some point as well. But the point that you raised, and again, just before I go to questions, my memories of the Corporate Manslaughter Act in England, and thinking about this just before I left to come out here, I remember being at some seminars there where it was being discussed. I think it was very much a policy thing, wasn't it? This idea of punishing corporations. Whereas in Hong Kong, we seem to have focused on the idea of individuals are in control. In England, the problem always seemed to be that you couldn't impute the sort of some sort of knowledge, some sort of directing mind to actually take responsibility in those situations. But I remember Mark raised that issue, and I wonder if it has come up, this thing of when originally the act was put forward, I think there was some criticism of the issue of if you're going to punish the company and it's going to be a financial punishment, then as Mark said, many of the companies are just they're going to fold. They're going to go into an insolvency procedure, which, okay, you'll get a fine against them or whatever else, but then the families of the individuals who died, who then want to sue, usually you wait for your criminal conviction and then you go for your civil case, using the criminal conviction, of course, to balance everything on. So, Mark, do you think that's a fundamental problem with the English statute?
Yes, I think that's a very good question. I don't think it's rather a fundamental problem with the statute. I think it's the English perception of the capitalist theory, because historically, if we look back to Solomon and Solomon company cases till today, the device of corporate structure was never really created for being liable or criminal sense. It was to manage the wealth. And look at the 200-300 years ago, the earliest structure of corporation was local council structure. And there were those kind of cases where individual was pursued after for liability as a corporate under the council liability. But none of them was actually being personal liable at all. And that's just kind of the message all the way till today. And so despite we have this corporate manslaughter and corporate homicide act in the UK, I think it's consistent with the tradition that it was never really intended to make individuals within the corporation to be liable. And like you say, also Tracy has shown as a common law, you can only pursue individually then sue the other safety and health regulations specifically, or strict liability. and in that sense. So it kind of create a parallel way proceeding. I think that's the best way the government trying to create it. But the policy, like you said, is right. It was born to the pressure because there's so many disasters happening in the 1990s. For example, typical one like Dangerous Dogs Act was passed because a lot of people were bitten by the dogs. So we have so many disasters in the 90s, and therefore this took sort of nearly 2 decades before the act was really, well, there was a draft the act, and before it was actually enacted in 2007 and enforced in 2008.
Great, thank you very much, Mark. Well, then if I can go to the questions we've been asked so far, and just remind everyone that you can check your questions in. We have a question from Shmuel Yerushalmi, and he's asking both of our speakers today if you think that we need more strong regulation and more involving of state authorities in the process of managing the medical and pharmaceutical industries. It's a bit wider, but for both of you. Maybe Tracy, what do you think?
I think the Hong Kong legislative government have made a start with the private healthcare facilities ordinance. This was actually stemmed from the incident, the death back in 2012. So they are making some progress with the enactment of those facilities. And it also is in response to, the need to protect the public and the increasing trend in Hong Kong as well with the aging population, and also with the growth of corporate healthcare centers, the use of daycare centers to move away from the public system through to private healthcare and the public and private partnership, where there's encouragement of the public to actually go to, for minor procedures or elective surgeries, etc., to move to the private sector to have that done. And so there is a need definitely for stronger regulation, in particular for like medical aesthetic operations. There hasn't been much attention of that in, say, the past 10 years, and there has been quite a growth in that area in Hong Kong. You just have to see the adverts for all these medical and beauty centers with these lovely ladies on the posters. But there is definitely need for greater regulation, and there has been developments in that area. In terms of, I can't speak in a lot of detail on pharmaceuticals regulations. In that respect, there are some provisions for, say, advertising of and practice promotion, any misleading adverts of pharmaceutical products, but I don't think that has caused that greater concern in Hong Kong. The focus has been in recent years on regulation of most of the medical profession, and also in the regulation of private healthcare facilities.
Thank you. I think I've lost Mark for the moment. I don't know if he's disappeared from my screen. I don't know if he's still there, Mark. But just to follow up, Tracy, though, just on coming from that, in your slides, of course, you'd raised the issue that medical practitioners are concerned, though, because of these cases as well. I mean, your focus here was particularly on that sort of beauty industry and where doctors were playing there. But you've obviously had that interaction with public healthcare officials and generally healthcare officials as well. Do you think that they are very concerned? You mentioned the concern.
Yes, they are very concerned. I've done a series of webinars on this topic, and time again, doctors are afraid that, from these cases, if there are deaths, I mean, they mentioned especially surgeons who encounter, surgical complications and, deaths of patients, sometimes through no negligence act. But the fact that they do occur, and with the public knowledge out there, the fact that it say patients die, then would there be pressure that the patients, the deceased families will go to the police, investigations and convictions. There is great concern of that. And I think that stems from the UK increasing trend there for where doctors involved in not as medical aesthetic practice in their daily practice have been prosecuted and convicted, and it has caused great concern both in the UK and in Hong Kong, whether Hong Kong prosecution would follow suit. So it is a topic which, it is of great concern of them. What I do say to them and really want to stress when I give them seminars and things like similar to this one is that they've got to be prepared. I don't believe personally there'll be an increasing trend of prosecutions against doctors in general. I don't believe that. There's the civil negligence laws, there's the disciplinary actions which patients' families can take where they consider there's issues of professional misconduct, but there is concern. But I think doctors, through increasing awareness of their own practice and the fact that this might not be an issue which they did consider at first, not to be overly worried, but to understand the necessary processes that they need to go through. And in particular, when taking informed consent, that procedure has always raised concerns, and there's always ways of improving that in terms of the comprehensiveness of the risks and benefits and alternative treatment options available to patients.
So do you think this is definitely linked in that idea of with the public health provision, when we have people acting within that, there's already perhaps a sense of regulation, a sense that there is the control there. So this is definitely focused more towards this more unregulated industry, as you focused on the beauty industry.
Yes, the beauty and the private industry in particular, and that's the reason why the new Private Healthcare Facilities Ordinance, as the name speaks for itself, is meant to regulate, and because that has been not an area of focus. The public sector has the regulations and is managed by a hospital authority, and it's always it's constantly in when there are any medical negligence cases arising from them, there's constant checks where there's deaths in the public hospitals, there's coroner's inquests. In that respect, there's lots of regulation changes being made, which is good through the processes. But the focus in the past couple of years and further for public health needs to be met, has to be from the private sector. And that's where the regulations would come in. And it's an interesting area to see how strict the regulator under the Department of Health will actually look into these facilities and make sure that they comply with the very detailed provisions through inspections and through the licensing scheme in future.
Well, actually, we've got a couple of questions that have come in linked into that, so thank you for that answer. First is, why is it cosmetic surgeons have been the focus here? Is it, again, I suppose it links into the unregulation, but doctors are working in hospitals have to bear liabilities too. So far, the incidents we've seen in Hong Kong involved only the most serious misconduct. Are we not getting prosecution for other things to do with cosmetic surgeons or cosmetic procedures in Hong Kong? Do you have any experience of this? I think I've seen reports of people being prosecuted where it's not been a death, but of course people have suffered serious side effects of wherever the treatment is.
Yes. In this question points in relation to gross negligence manslaughter or just general negligence actions or disciplinary?
The idea is there more to do with general negligence? I think that's the point of the question.
Yeah, I think in general, the focus I've on this talk is on gross negligence manslaughter, the very the most serious of cases where there are deaths, unfortunately, of patients. But in general, in Hong Kong and of the medical profession in general, there is, unfortunately, increasing complaints and claims against the medical profession in whatever practice area that they conduct. And the medical profession in general, not just in Hong Kong, but globally, are under increasing scrutiny and being held accountable. Individual doctors, not just the doctors, healthcare practitioners, allied healthcare workers like nurses. I've worked with like physiotherapists, which have been, sued and also being complained by regulatory bodies. And there is increasing scrutiny of the profession and questions by the public. Patients now are more vocal than ever. They've got the internet at hand. They've got medical journals available. They've got friends. They've got articles they can read in the news about, all the possible actions that they can find, doctors and people involved in their health accountable to, complaints about, side effects, adverse effects of the treatments given. But it's a global trend, and there are unfortunately increasing complaints and claims, both negligence and, even now, holding, doctors and personnel responsible criminally with severe punishment.
Yes, I think everyone today is an expert now that we have Google. So we can all check up on these things. And of course, for the litigation, we have to blame lawyers, I'm afraid, the increased litigation for the whole idea. I see Mark's back, and he's in his library now. So nice to see you back, Mark. I think when you left us, we were just, the question had come in just about the idea, should there be more regulation of the medical and I think the pharmaceutical industry. And Tracy had given us her views about that there is going to be more regulation, or there is already regulation in Hong Kong, but there's also going to probably be more regulation as well. What about in the UK? What's the situation there, Mark? Regulation of the health industry? I don't know if you can unmute yourself. Let me see. You can't unmute yourself. Okay. Let me see if I can unmute you. No, I don't know if I can actually. No, I can ask you to unmute. Oh, there you are. I think you're back.
Yeah, Steve, you read my mind. Actually, I wasn't able to unmute until now. Thank you. Sorry, I apologize to everyone. I got cut off, but I do have an advance notice from Virgin Media that there will be a disruption on my networks. Yes, sorry, Steve. I was trying to work it out, the unmute system. So do you mind to rephrase your question again?
Sure. It was a question that came in from Shmuel earlier, and he was just asking about, do we need more strong regulation and more involving of state authorities in the process of managing of medical and pharmaceutical industries? And Tracy had been talking, I think, mainly, well, saying generally there is a lot of regulation, but I think focusing particularly on Hong Kong. What about in the UK?
In terms of particular sector, I don't really follow on that. But I think if you look at whole corporate manslaughter and corporate homicide acts, it apply across the whole industrial sector, including university, and apart from the public service organization. So virtually, this particular act added on or strengthened on the existing industrial safety and health regulations. So I couldn't really answer again for the medical aspect, but it's become a growing trend as well in the UK. And funny enough, I'm not marketing Leicester Law School. We do run parallel together with the medical school hospital to the medical doctor students on the negligence under the top modules on the professional negligence and ethics in a way to strengthen this kind of standard. I think there's a growing trend of litigation pursued after medical fields or individual professional. So it becomes kind of important for them to aware their responsibility and the boundary and the possible legal claim against them in terms of their proceeding or advice in medical aspects. Yeah.
Okay. Well, I think there are two more questions that come in linked into these things as well. The first is, if criminal liability is not pursued against a corporation, should we impose heavier civil liabilities, especially fines on corporations, whether they are construction companies, medical cosmetic companies, or others, for the injuries that are caused? So
yeah, I can try to answer that one. Take UK, for example, the Cosworth's case was the very first one pursued after the corporate manslaughter and the homicide acts. And in fact, it's pretty much using Adomaco, the similar what Tracy was saying, and the principle as the standard for jury design. But at the end, the outcome is pretty much a civil outcome. It's a fine. and it actually was funded for £385,000. And it's a mid-size, quite a small towards mid-size corporation running on a theme park, provide leisure activity for younger children, like the typical case as well. But like I say, 2 years later of the conviction, it moved into insolvent proceedings and to close down. And I did chat with Tracy earlier. There was another case recently happening to Leicester school kids who went on a leisure center, and one of the girl was drowned in one of the activities, and they pursued after this theme park, and then which succeeded it, but the theme park was sold later to one of the company, which is within a group, with £1. So while you can say yes, the fine can be unlimited and you can increase the fine continuously, but the corporate structure always allow them way out by dodging the liability and by incorporate a new one or transfer the asset in that sense. Yeah.
I suppose that's a problem. Tracy, do you think that's something in Hong Kong, that there should be heavier civil liabilities? I mean, you mentioned that one case where there was a $3 million fine.
Yes.
The company. I mean, was there a civil? I take it there was a civil case afterwards, or some sort of settlement with the families. Has there been any details of that?
I haven't found, I'm not aware of details of those. I can imagine there would have been settlements, so there weren't reports of that. But unfortunately, you know, there's the civil claims and then there's the criminal justice system. And unfortunately, we can't really say, oh, for this case, you know, we're not going to pursue, you know, the, criminal prosecutions. And so we should receive, higher compensation for the unfortunate victims or their families. In this case, I mean, the civil justice system ensures that any compensation pursued has to be reasonable, based on compensating the victims or the injured persons or their families, what put them back in a position but for the incident. So in that ways, we can't just transfer in the interest of justice to do that. But we just can't look at it from that perspective. But what is just compensation has to be assessed, according to the common law and what the courts consider is just.
Okay, thank you. And again, it's sort of linked into the penalising side of everything here. I think possibly for both of you, but maybe for Tracy more, do you think that the Hong Kong courts are stricter in their punishments with the companies than the English courts under the common law in England originally? The example that's been mentioned is the Adamoka case, where you said that I think there was a suspended sentence given to the surgeon, wasn't there, in that one?
Yes.
Whereas, of course, in Hong Kong, we're seeing these cases quite hefty terms of imprisonment being given out. I know there are very different facts, but it's just a sort of idea. Do we think that the Hong Kong courts are a bit stricter in that way, or a bit tougher?
Yeah, I agree. I mean, when you compare the prison sentence imposed in England and in Hong Kong, because there's no there is no sentencing guidelines for gross negligence manslaughter at all. So it was very much up to the sentencing judge to determine the necessary sentence in both cases. I believe that the counsel for the defendants did try to submit cases from England and Wales, where it carries a much lower prison sentence, but unfortunately the Hong Kong courts don't have to take that into account. They consider it's completely different set of circumstances, different jurisdiction, and the fact that there was no sentencing guidelines and the public outcry, not just in Hong Kong but worldwide, on the particular facts of the DR cases and the fact that this incident happened affected, it was not just one individual who the lady who passed away, 2 others were actually severely injured as a result of blood poisoning, septicemia. Lady had her limbs amputated. She's subjected to a wheelchair now. The others, I believe, they also suffered some serious injuries, and it was actually a warning, and it's actually in the hands of the courts to set this. And I think it has that effect, that it warns that when you hear of hefty sentences, like 12 years for the owners, 10 years for the technician, even for the Dr. Magna case, even though there was reductions and she was, in a way, it seems more remote, and from the actual cause of the death, it was still it's still much heftier sentence than England. But that's definitely, I agree, the Hong Kong courts are stricter in that sense.
I think, obviously, with all of those factors as well, the court had to send out a message. But as you said, I think particularly in the DR case, it was Dr. Chow as well, wasn't it?
Yes.
That idea that it was just a commercial venture, that he was just interested in selling this product. And as you said, there was no remorse or anything at all shown for any of the terrible things that had happened to the victims of everything there. I did have I'll come to Mark. I'll come to the next question after. Mark, do you think in England, because the Act allows that the officers of the companies can be, I think, held personally accountable for the criminal activities as well, have there been many cases where the officers have been sent to prison, sort of following up on that sort of strictness in Hong Kong?
I suppose yes. That's a part which I haven't really followed on individually, because my focus is looking into how corporate will be liable criminally for Manslaughter Act. Yes, they do have the parallel pursuing under the Safety and Health Act for failure compliance, certain things. Individual will pursue on that for the sentencing liability. But very important one note is that if individual found within the corporations for being the senior level and the corporate being found liable, the individual directors who hold a position can be pursued later by the prosecutor for disqualification as the director for the 5 years or 10-year duration. So that kind of added a bit sanction to that individual liability to it. Yeah.
It doesn't sound as much of a sanction as the Hong Kong court sending people to prison for 12 years and things like that.
Yes.
Definitely, I think that what we said earlier, there's definitely that policy, I think, behind the UK Act. It's to punish the corporation more than it is the individuals, whereas in Hong Kong, it's definitely holding individuals account for these terrible things more than anything else. We are running out of time, but I did have one question. It was something I was trying to work out as well. But someone's asked, cytokine-induced killer cell therapy. What was it meant to do? Because you said it's a cancer treatment, I think, isn't it, Tracy?
Mm-hmm. What's meant to do is these cytokine-induced killer cells are actually naturally in our blood. In our bloods, part of, I think there's some white blood cells. I'm not medically qualified here, but what it's meant to do is when you extract the blood from these particular individuals and then they're cultured in the laboratory at high temperatures, and what it's meant to do is induce the production, the great multiplication of these killer cells, they sound like killer cells. What they're meant to do is kill the bad cells in your blood system, in your body. So it's an experimental treatment for cancer patients where obviously they've got the tumors and their immune system is low. What it's meant to do is boost their natural immune system, in a way natural, in their own blood, so they can fight against the cancer cells. It's usually, I don't think it's strong enough to kill off all the cancer, but it's usually used as a palliative treatment, what we call providing less painful, to provide relief from the pain and from suffering at late stage cancer patients.
But in these centres, were the people who were being given to actually suffering from some form of cancer, or was this you said it was almost an experimental treatment even for cancer at that time, and probably still is to a certain extent. So were they just how did they sell it to them? They just said,
Yes,
this is good.
yeah. For in this case, they sold it as to boost the well-being and immune system of healthy patients. So you're well, you don't have cancer, but you want to be more healthy, boost your immune system, say, naturally. And what they did do through this case was these treatments is actually being carried out in on the mainland in Guangzhou and also in university in Japan. So there was staff and research which the company and also sent Dr. Mack and individuals from the DR group to, I think it's military hospital in Guangzhou, to actually where this treatment is actually being given. So it is being given in, provided not just to cancer patients, I think to, it's a kind of new alternative type of therapy, which is given. And that's the way it was promoted really, and it was to boost your immune system. Even though you're healthy, that you can be more healthy.
Okay. Well, the next time I go to my beauty therapist, I will be very careful about the products
Yeah.
I invest in at that point. But thank you very much, Tracy. So look, thank you very much, Tracy. That was excellent, your presentation, really interesting. And thank you very much, Mark, as well, for being involved in the discussion. I'm sorry we lost you at one point. You had warned us that perhaps your internet might be intermittent at times. And of course, you've had a very traumatic morning already for events that have happened in England as well. So again, thank you very much for joining us.